Welcome to Drishti Judiciary. This MCQ series for the Supreme Court Clerk Exam will sharpen your accuracy, strengthen concepts, and help you master the exam pattern. Let's begin. Let's start with previous day's practice question. The question was, a dash injunction can only be granted by the decree made at the hearing and upon the merits of the suit. The defendant is thereby perpetually enjoined from the assertion of a right or from the commission of an act which could be contrary to the rights of the plaintiff. A. Perpetual. B. Temporary. C. Both A and B are correct. D. None of the above. The correct answer is option A. A perpetual injunction can only be granted by the decree made at the hearing and upon the merits of the suit. It is a permanent order that perpetually enjoins the defendant from asserting a right or committing an act that could be contrary to the rights of the plaintiff. Hence, A is the correct option. Let's start today's session. The first question is, whether any appeal is allowed against the order or decree passed in any suit instituted under Section 6 of the Specific Relief Act 1963. A. Yes, appeal can be allowed. B. No appeal shall lie from any order or decree passed in any suit instituted under this section, nor shall any review of any such order or decree be allowed. C. Appeal can be allowed if permitted by the court who have given the order or decree. D. None of the above. The correct answer is option B. Section 6 of the Specific Relief Act 1963 deals with suits relating to the recovery of possession of immovable property in cases of dispossession without consent or due process. The Act specifically restricts any appeal or review against an order or decree passed in such a suit. Section 6, subsection 2 of the Specific Relief Act 1963 clearly states that no appeal shall lie from any order or decree passed in a suit instituted under this section, nor shall any review of such order or decree be allowed. Thus, no appeal or review is allowed in suits filed under Section 6 of the Specific Relief Act. Hence, B is the correct option. Next, when an under trial has been detained for one half of the maximum sentence for the offence, BNSS permits release on personal bond except where the offence is punishable with life or death or the person faces multiple pending cases, the offence is bailable, the accused is below 18 years, or the charge sheet is delayed. The correct answer is option A. BNSS restricts this default release in life or death cases and where several prosecutions are pending. Hence, A is the correct option. Next, a proclaimed offender in an offence punishable with at least 10 years imprisonment continues to evade arrest. What may the court do under BNSS? Postpone proceedings indefinitely, dismiss the case for want of presence, proceed with trial and judgment in absentia if arrest is improbable, or refer matter to the High Court for further orders. The correct answer is option C. BNSS permits trial and judgment in absentia against proclaimed offenders for serious offences if no prospect of arrest exists. Hence, C is the correct option. Next, according to Section 23 of the Indian Contract Act 1872, which considerations and objects are unlawful? A. Where it is forbidden by law or defeats the provisions of any law. B. Which is fraudulent. C. Which is immoral or against the public policy. Or D. All of the above. The correct answer is option D. Section 23 of the Indian Contract Act 1872 defines what constitutes unlawful considerations and objects in a contract. Hence, D is the correct option. Next, which of the following statements is correct regarding offer? An offer must be made to a specific person or group. An offer can be made to the public at large. An offer must be made in writing. Or an offer must be accepted immediately. The correct answer is option B. An offer does not necessarily have to be made to a specific person or group. It can also be made to the public at large. This is known as a general offer or an offer to the public. In such cases, anyone who fulfills the conditions of the offer can accept it. For example, if a company announces that it will pay a reward to anyone who finds and returns a lost item, this is an offer to the public at large. The individual who finds the item and returns it would be deemed to have accepted the offer and consequently would be entitled to the reward. Hence, B is the correct option. Next, the President nominates 12 members of the Rajya Sabha according to their performance as office bearers of cultural societies, the recommendations made by the Vice President, their role played in political setup of the country, or their distinction in the field of science, art, literature and social service. The correct answer is option D. their distinction in the field of science, art, literature and social service. Hence, D is the correct option. Next, which landmark case led to the removal of adultery as an offence in the BNS? Navteej Singh Johar vs. Union of India, Joseph Shine vs. Union of India, Mithu vs. State of Punjab, or Independent Thought vs. Union of India. The correct answer is option B. The Supreme Court struck down Section 497 IPC in Joseph Shine 2018, declaring it unconstitutional under Articles 14, 15 and 21. Hence, B is the correct option. Next, which of the following offences has been introduced under the BNS? Mob lynching, child marriage, polygamy or begging? The correct answer is option A. The BNS penalizes mob lynching when 5 or more persons murder someone based on identity markers like caste or language. Hence, A is the correct option. Next, delay in filing the suit. A. Cannot be condoned. B. Can be condoned under Section 3 of the Limitation Act 1963. C. Can be condoned under Order 7, Rule 6 of the Code of Civil Procedure 1908. D. Can be condoned under Section 5 of the Limitation Act 1963. The correct answer is option C. Delay in filing the suit can be condoned under Order 7, Rule 6, where the suit is instituted after the expiration of the period prescribed by the law of limitation. The plaintiff shall show the ground upon which exemption from such law is claimed. Hence, C is the correct option. The last question is, under Order 20, the procedure for summary judgment is provided for cases where there is a dispute over a large sum of money, the defendant does not have a defense to the claim, there is ample evidence in dispute, or the suit involves multiple parties. The correct answer is option B. Order 20 of the Civil Procedure Code 1908 deals with the procedure for summary judgment. Under this procedure, the court can give a summary judgment in a case if the defendant does not have a valid defense to the claim. This is generally applied in situations where the court believes that the claim is clear and no substantial defense is raised by the defendant. The goal is to avoid unnecessary prolonged litigation where there is no real dispute to be adjudicated. Hence, B is the correct option. Now it's time for the practice question. The question is, under the CPC, when can the doctrine of res judicata be invoked? Only in criminal proceedings? In subsequent suits involving the same parties and same cause of action? Only when the defendant is absent? Or in cases of fresh evidence? Send the answer to this question in the comment section. That's all for today's MCQ session. If you found this helpful, don't forget to like, share and subscribe to the Drishti Judiciary YouTube channel. See you in the next session. Keep preparing.